In his relatively short career litigating in this district, Liebowitz has earned the dubious distinction of being a regular target of sanctions-related motions and orders. Indeed, it is no exaggeration to say that there is a growing body of law in this district devoted to the question of whether and when to impose sanctions on Mr. Liebowitz alone. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So another copyright troll, I'm putting this in air quotes because I don't want to get sued by Richard Liebowitz. I don't have any personal experience with Richard Liebowitz directly. I have never defended anyone from him that I know of. I think it was Isaac somebody was a different one who was doing a website where you'd get an accusation of copyright infringement and you'd go to a website and type in a username and password, and then they would give you like an option to settle for a small amount of money, relatively small amount of money, and it was often a good idea. But I think this is different. I think what Richard Liebowitz is doing is running one of those photo sites, or some of his clients, should I say, run things like photo sharing sites where if someone then takes a photo off of the site and doesn't give proper credit, they sue for copyright infringement. Richard Liebowitz was recently achieved a settlement in one of his many hundreds of cases in the Fire Festival lawsuit over the documentary that was on Netflix. There was an allegation that some of the stock footage or B-roll footage or footage that was used in the Netflix Fire Festival documentary was illegally obtained or unauthorizedly used and not a fair use. And so Richard Liebowitz was the attorney behind the prosecution and achieved a settlement. He was recently sanctioned by Judge Denise Coate, February 22nd. She sanctioned him for $10,000, later reduced to $2,000 for failing to notify of a pre-trial conference in a matter. And she was upset by his astonishing volume of filings, coupled with an astonishing rate of voluntary dismissals and quick settlements in his cases in this district, which I guess is Southern District of New York. I think that's where she is.
Yes, New York.
And he has filed over 700 cases since 2016, 500 of which have been voluntarily dismissed, settled or otherwise disposed of before any merits-based litigation. The cases are usually closed within 3 months of the complaint filing. Well, okay, so I swear, I'm not defending Richard Liebowitz, but this is normal for copyright trolling. They file a case, and how would you tell the difference? Let's go through this for a real quick second before we get into Mr. Leibowitz's case with Jesse Furman, the judge in the census citizenship case, who is also tossing Richard Liebowitz, I believe, out of court. We'll see what he has to say here. But as far as why Richard Liebowitz would be doing something like this, how would it look if it was a legit copyright claim versus a copyright trolling claim? I don't know if there's a lot of difference. A legitimate copyright claim would look like someone going to court, serving a defendant. The defendant hires an attorney. The attorney decides this is better off settled, contacts the plaintiff's attorney. We negotiate a settlement. We sign a settlement. The settlement includes all the language that defendants want, like no admittance of liability, complete confidentiality of terms, release of liability, all that stuff. None of that goes to the judge. The settlement just specifies that the case will be voluntarily dismissed. So you get the case voluntarily dismissed. It doesn't tell the judge what happened. How is that copyright trolling? Whereas if you're a copyright troll, all of that's the same. You still have to do all of that, except now you're just doing it en masse. Well, what's wrong with Mr. Liebowitz just having a business where he represents plaintiffs? Let's take a look. Maybe some of our questions will be answered here by Jesse Furman, United States District Judge for the Southern District of New York. In his relatively short career litigating in this district, Liebowitz has earned the dubious distinction of being a regular target of sanctions-related motions and orders. Indeed, it is no exaggeration to say that there is a growing body of law in this district devoted to the question of whether and when to impose sanctions on Mr. Liebowitz alone. See Pereira, McDermott, Steger, and Craig. This opinion is the latest contribution to that body of law. For the reasons stated below, the court concludes that sanctions should be imposed on Mr. Liebowitz for his repeated failure to comply with this court's orders, failures that imposed considerable and unwarranted costs on the court, its staff, and defendant, NBC Universal Media. Plaintiff John Curtis Rice filed this complaint bringing claims under the Copyright Act. On January 16th of this year, the complaint alleges that NBC infringed Rice's rights by displaying a copyrighted photograph depicting the removal of a wild raccoon from a beauty shop in the Bronx on one of its websites. More specifically, the complaint alleges that NBC did not license the photograph from plaintiff for its article, nor did NBC have plaintiff's permission to consent to publish the photograph on its website. NBC is not and has never been licensed or otherwise authorized to produce, publicly display, distribute, or use the photograph. On January 17th, the court ordered the parties appear for an initial conference May 2nd and ordered them to conduct a mediation session prior to that initial conference. NBC maintains, as it has since early in the case, that it did not infringe plaintiff's copyright because it had a license for online use of plaintiff's photograph. It docketed the thing at number 15, paragraph 3, provided the affirmative defense that NBC Universal has an express or implied license to utilize the photograph. In or about mid-March 2019, according to defense counsel, NBC produced the evidence supporting its complete license defense by disclosing to Liebowitz a $200 invoice for the online Today Show use of the image of raccoon capture in Bronx, New York. Following a discussion with his client, Liebowitz took the position that the license was for 1 year and that the 1-year license had been exceeded. Liebowitz did not, however, produce any documentary evidence to support his position, nor did he amend the complaint to correct the allegation that there was no license or permission to publish the photograph. On April 1st, 2019, the court-annexed mediation program closed the mediation referral, noting in the docket entry that one or both parties failed, refused to attend, or refused to participate in mediation. In a joint letter to the court in advance of the initial conference, defense counsel represented that NBC Universal had indicated that it was willing to participate in mediation and provided available dates to the mediation office, but plaintiff did not. Liebowitz now blames his client's unavailability for his own failure to attend mediation. Sanctions should not be imposed for Rice's inability to attend mediation, but Liebowitz did not inform the mediation office of this conflict, let alone the court. Instead, as defense counsel notes, Liebowitz simply did not respond to the mediation office's scheduling emails. As of the initial conference, no mediation session was held and no relief from the mediation order had been sought or granted, a clear violation of the court's January 17th scheduling order. On May 1st, Liebowitz filed 2 requests with respect to the May 2nd initial pretrial conference. First, at 3:19 p.m., he filed a letter motion requesting the court change the time of the conference from 3:45 p.m. to 10:45 a.m. The court grudgingly granted the request, noting that it would have been on firm ground denying it on the ground that it's untimely and inadequately explained. The court warned that at the May 2nd conference, counsel should be prepared to explain the timing and reason for the request. Later that same day, 11:09 p.m., Liebowitz filed a stipulation of voluntary dismissal signed by both parties, and 6 minutes later, a letter motion to cancel the May 2nd conference. The court denied the request to cancel the conference. In denying the request, the court ordered counsel to appear as scheduled, in part so plaintiff's counsel can answer for his apparent failure to comply with this court's orders and rules, including its orders regarding early mediation. Despite the court's clear order, Liebowitz did not appear for the May 2nd conference. I'm trying to look at that camera. When the court staff contacted Leibowitz's office, it got somewhat conflicting information about whether he was out of town or on his way. At the conference, the court asked defense counsel to explain what had occurred May 1st and before. Notably, defense counsel advised that until the eve of the initial pretrial conference, plaintiff continued to press for settlement, despite the evidence of a valid license. The court also noted at the conference that it would sign the stipulation of dismissal, retaining jurisdiction to adjudicate any sanctions issue. Later that day at 4:04, the court signed and docketed the parties' stipulation of dismissal. By endorsement, the court specifically retained jurisdiction to consider whether sanctions should be imposed upon plaintiff's counsel. The court also ordered Liebowitz to show cause in writing why sanctions should not be imposed pursuant to Rule 11 and 16 of the Federal Rules of Civil Procedure and the court's inherent authority. In response, he submitted 2 declarations, and defense counsel submitted a declaration and letter with billing records. Discussion. It is well established that when counsel violates a court order or fails to appear at a conference, sanctions may be imposed pursuant to either Rule 16 of the Federal Rules of Civil Procedure or the court's inherent authority. Such sanctions may be imposed in response to a motion or by the court on its own. Moreover, the court may impose sanctions on the lawyer or the lawyer's law firm. The decision whether to impose sanctions is left to the court's discretion. The court begins with Rule 16. 16F authorizes sanctions for, among other things, the failure to obey a scheduling or other pretrial order. In deciding whether a sanction is merited under 16F, the court need not find that the party acted in bad faith. The court need only find that there is clear and convincing evidence that counsel disregarded a clear and unambiguous scheduling or other pretrial order. The court has no trouble making that finding here. January 17th, the court ordered that unless and until the court orders otherwise, the parties shall schedule a mediation to take place no later than 2 weeks before the initial pretrial conference. The 17th court order further stated that if the parties believed that early mediation would not be appropriate, they shall file a letter motion seeking relief from the foregoing requirements no later than the deadline to answer. The deadline to answer after extension was April 3rd. Neither party sought relief from the early mediation requirement by that date. Instead, on April 1st, the mediation office reported that the court-ordered mediation was not held as one or both parties failed, refused to attend, or refused to participate. The records reveal that Liebowitz was to blame for that failure to comply with the January 17th court order. Defense counsel explained that when the mediation office reached out, we reached out and tried to get a phone call together with both attorneys and the mediation office. Mr. Liebowitz did not respond, leading to the subsequent closing of that file by the mediation office. Notably, Liebowitz does not dispute this. Instead, he argues that sanctions should not be imposed for the failure to mediate because his client was not able to find the availability to take a day off of work. But Rice's purported lack of availability does not excuse Leibowitz's failure to comply with the order. Liebowitz could have sought relief from the court's order on account of the unavailability, but he did not do so. He simply failed to respond. That clear violation of the January 17th order, which was intended to facilitate early resolution of the case, merits the imposition of sanctions under Rule 16F. And how about the court's inherent authority? The court also imposes sanctions for Leibowitz's failure to comply with the court's orders pursuant to the court's inherent power to award sanctions. District courts have the inherent power to sanction a party for bad faith conduct violating the court's order, even if procedural rules exist which sanction the same conduct. Under this inherent power, a court may assess attorney's fees as a sanction for the willful disobedience of a court order. To warrant an award of attorney's fees pursuant to the court's inherent authority, the court must find that Liebowitz acted in bad faith or that he willfully disobeyed the court's order. Applying those standards here, the court finds it appropriate to impose sanctions to its inherent authority for Leibowitz's failure to comply with both the January 17th order mandating early mediation and his failure to appear at the May 2nd conference. In response to Leibowitz's literal 11th hour request to adjourn the conference in light of the stipulated dismissal, the court explicitly ordered that counsel shall appear as scheduled, yet Liebowitz failed to comply. Liebowitz now claims that his absence was excusable because he believed that the court lacked jurisdiction to conduct a Rule 16 conference after the parties signed the stipulation of dismissal. That claim is unpersuasive, and the court finds disingenuous. First, it is hard to credit, given the letter filed by Liebowitz himself requesting adjournment of the conference 6 minutes after filing the stipulation of dismissal. Second, the claim is without merit as a matter of law because voluntary dismissal does not preclude the district court from considering collateral issues such as sanctions. Thus, even if the court no longer had jurisdiction to order attendance at a Rule 16 conference, a dubious premise at best, it plainly had authority to consider sanctions and to mandate counsel's appearance at a conference related to sanctions, as the May 2nd conference was. Third, Leibowitz's claim is hard to credit because other courts in this district have imposed sanctions on him even after settlement and dismissal. And finally, attorneys have no absolute right to be warned that they disobey court orders at their peril. Accordingly, the court declines to credit Leibowitz's statement that he believed the court lacked jurisdiction to hold a conference and declines to excuse his absence on that basis. Additionally, the court finds for several reasons that Leibowitz's disobedience to the court orders was willful. First, these orders were explicit, and there is no suggestion that Liebowitz misread or misunderstood them. Where's second? Second, because the court declines to credit Leibowitz's excuses for his behavior, there is no good faith explanation for his failure to comply. Third, Leibowitz failed to comply with the court's mediation order for several months, and his failure to comply is not isolated but rather part of a pattern of noncompliance in this case and others. In short, because the court finds that Leibowitz willfully disobeyed the court's order, it is appropriate to impose sanctions on Leibowitz pursuant to the court's inherent authority. Under Rule 16F, instead of or in addition to any other sanction, the court must order the party, its attorney, or both to pay the reasonable expenses, including attorney's fees, incurred because of noncompliance. That is, the court must award fees, but the fees that may be assessed are limited to those incurred as a result of the violation. By contrast, the court's inherent power to impose sanctions includes the power to impose at its discretion attorney's fees representing the entire cost of litigation. For example, in the Chambers case, the Supreme Court upheld the finding that full attorney's fees were warranted due to the frequency and severity of the lawyer's abuses of the judicial system and the resulting need to ensure that such abuses were not repeated. In light of those principles, the court finds, pursuant to Rule 16 and its inherent authority, that a single monetary sanction equal to the reasonable attorney's fees incurred by the defendant from April 18th onward is appropriate. April 18th is the date by which the parties were ordered to conduct mediation. Thus, from that point on, Leibowitz was unambiguously in violation of the court's mediation order, and that violation is not without costs. The court ordered early mediation because, in its experience, cases of this nature often benefit from early mediation. In over 700 cases Mr. Leibowitz has filed since 2016, over 500 have been voluntarily dismissed, settled, or otherwise disposed of before any merits-based litigation, making Leibowitz's failure to mediate a likely cause of additional legal expenses. To the extent that award also covers time defendants spent responding to Leibowitz's misconduct, including time wasted responding to settlement demands that the evidence revealed were inappropriate, such compensation is proper. In opposing a monetary sanction, Leibowitz invokes Rule 11C5B, which states that the court must not impose a monetary sanction on its own unless it issued a show cause order under 11C3 before voluntary dismissal or settlement of the claim. But Rule 11 does not repeal or modify existing authority of federal courts to deal with abuses under the court's inherent power, and the inherent power of a court can be invoked even if procedural rules exist which sanction the same conduct. Under this precedent, the court's inherent authority to impose monetary sanctions is not subject to limitations in Rule 11C5B. The only remaining questions are whether the sanction should be imposed on Leibowitz alone or also on his firm and the amount of such sanctions. As to the first issue, because Leibowitz's actions were indistinguishable from those of the Leibowitz law firm, the court imposes sanctions on both. As to the second, the attorney's fees are approximately $8,700. This is based on 17 hours of work at rates ranging from $180 to $570 an hour. I aspire to be the $570 an hour attorney. Even the highest of those hourly rates is reasonable for copyright infringement work in the Southern District of New York. Finding of $630 per hour is well within the range, and $540 an hour are well within the range. I picked the right line of work, everyone. I would just like to say that I just need to figure out how to get someone to actually pay me $540 an hour. We're working on that, though. The court also finds that around 17 hours of work is appropriate and reasonable, given that Leibowitz's inappropriate conduct created the need for a defendant to expend additional time on the case. Thus, the court finds the attorney's fees of $8,745.50 are reasonable and are properly imposed as sanctions. and they need to be paid within 30 days of this opinion and order. And that is Jesse Furman, United States District Judge for the Southern District of New York, who also recently ruled in the census citizenship case. And that was where all of the president's attorneys tried to bail on the case. Go watch our video on that. It's really, really good. What do you think? What do you think of that? Mr. Liebowitz does appear to be quite the copyright troll. It seems like the court wasn't even necessarily upset that Liebowitz filed yet another lawsuit. Oh well, it was that Liebowitz didn't follow the court's very, very, very basic rules. And if you are an attorney, or if you're studying to be an attorney, you have to know your rules of professional conduct. And Rule 1.1, literally the first effing rule in the book, is your duty of competency, which is a comprehensive rule that just says, it's literally a couple words. It says a lawyer has a duty to be competent at all times during representation of a client. And what does competency mean? It means that you have all of the knowledge, you can gain the knowledge that you need, you have all the resources, including the financial resources, to take on the representation of a client. If you look at the case and you see that you're going to need to do this, and this, and you can't afford to do those things for your client, even if your client pays for them or something, then you have to say, I'm not competent. I mean, you don't have to say that out loud, but you have to decline the representation, because you have to say to yourself that you're not competent. In this case, the duty of competency is implicated in Liebowitz taking on so many cases that he can't respond to them in time, or that he misses these things, or that he just doesn't care about any one case, because look at all the other cases that he's got. It doesn't matter if that one plant dies, because he's got a whole field full of plants. Well, this isn't farming and harvesting. This isn't farming simulator. This is lawyer simulator. And those plants, it costs. If you've wasted the court's time, the court can sanction you. So that's what he's being accused of here, or actually being found of having wasted the court's time. The NBC had a license, and Liebowitz didn't just automatically dismiss the case instantly before the mediation date, or otherwise file documentation asking the judge to handle things differently. You just have to talk to the judge. The hard part is you really just have to talk to the judge using the legal procedures available. That's really as hard as it is. As long as even if you file the wrong thing, the fact that you're doing it is sort of good faith. Now, if you filed the wrong thing on purpose, that's different. I'm talking about if you're not sure, if you're an attorney and you're not sure, do I file this as a letter motion or a regular motion? Maybe you call chambers and ask, or maybe you do file something as best as you know how, and then something will be dealt with on the back end. Don't just abandon the thing and not show up to your court appearances, pre-trial conference, phone calls, or whatever, or any of that stuff. Your mediation conference in this case. That is our show for today. I, of course, am Leonard French, your favorite copyright attorney, and this is Lawful Masses with me, Leonard French. Thank you very much to our Patreon and sponsors and other supporters. In July, we have a $500 plus supporter, Joshua Davis with TandaPay. We're working on a video for him about his social insurance program that's based on blockchain technology. Thank you to our $50 plus supporters, John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Richard Fournier, Spirit Bear, Jan Negrey, Daniel Perez, and Snorre Wisotzky. And thank you to our $5 plus supporters who are scrolling on the LED panel behind me. And everyone will appear in the description below. So thank you all for joining me. I'll leave some room for, we now have a dog pool party video of Nico in a shark life jacket. It's got like a little shark fin on the back of it. So we'll post that with the end of, in the outro of the videos. Love you all. Have a great Wednesday and a great rest of your week. We'll see you in the videos that drop, and on Sundays at 10 a.m. on twitch.tv/lawfulmasses, and I guess now Wednesdays at 7 p.m. Eastern, same place. Love you all. This has been Kaylee in the real studio, and then Tactical and Brandon in the virtual studio. Thank you much for joining me, everyone.